adopted, and if I recall correctly, Mae Nan, without any dissent on the debate floor.
May have been one of the only unanimous things that we did, other
Yes,
than voting to adjourn. We are running very close to break time, and since this is supposed to be a conversation, I really would like to open it up to the audience to see if there are any questions of this distinguished panel, or even comments. It doesn't have to be a question. Again, yes.
I'd like to hear from the panelists about the provision that was stricken by the people in 1988, I believe. The provision that provided that we will, the safety net, the social safety net, that people for reasons of age, infirmity, or misfortune shall receive the assistance of the state. What was the discussion at the convention about the importance of that? And I guess that would be. And I'd like to know if you ever think we're going to be able to go back to the intent, because I remember the debate at the time where people said, well, if we turn our backs on the needy, we're going to end up filling our jails with the people who need the assistance of society. And I think history has proven that to be true.
I can answer this, that with respect to the 1889 Constitution, which of course was required for Montana to become a state, there were provisions in there that provided protections for the citizens of Montana. When our committee met, I made the statement that we've got to make absolutely certain we do not take away any rights that are announced in the 1889 Constitution. I think there were a number of us that understood that we were going to face a tremendous campaign against the Constitution when we were done. And the one argument we did not want is that the new Constitution took away rights that the Montanans had enjoyed for 80 years. And we even put a provision in there that I frankly was opposed to, but I just felt I couldn't take it out. And Judge Nelson and Betsy will probably fully appreciate this. We have a provision there that says in libel and slander suits, the jury shall decide the questions of law and fact. And that was in the old Constitution. To me, I think it's out of place. I think the court should have the right to determine whether or not there's enough evidence or enough facts to justify the matter going to the jury. But that was carried over from England. In 1790, there was the Fox Libel Act to try and defeat the king that was putting people in prison over so-called libel and slanders against the monarchy. And so the Fox Libel Act wanted to make sure that he wasn't going to have that control, and it said the jury shall decide both the law and the fact. And that's caused our court some problem. But we did not take that out. We made sure that everything that was in the old Constitution that was good for the individual, that provided protection, provided basic rights, stayed right there, and then we added the things that we're talking about today.
Right, but I think what he is getting after, and this is, to me, this is the crossroads that we are at politically. And earlier, Attorney General Bullock raised the question whether our fundamental documents are the cause of the disconnect we are having today, or whether our documents work, and it's the people who aspire to offices under those constitutions. Almost every amendment to the 1972 Constitution has, in my opinion, either taken away rights that were given to them by the Constitutional Convention and the voters when they approved the Constitution, or weakened the power of the legislative branch, the people's branch of government. And I just find that so ironic that we have, the people of our state have been gradually eroding constitutional protections. The one you mentioned happened in 1988 by a constitutional amendment where we had our Constitution of 1972 had declared that public assistance was a constitutional right. That was amended to say only if the legislature decided to provide public assistance was it a right. Now, I think an argument can be made that the Dignities Clause of Article 2, Section 4 could be interpreted to require the government to recognize that people have a fundamental right to eat and to have housing. But as the Constitution has been amended, public assistance is not a fundamental right. Likewise, I think the amendment, the marriage amendment, took away rights that were granted. We basically, by a constitutional amendment, relegated gay people to not being able, as a constitutional matter,